Hello and welcome to the Herrington Carmichael Employment Law video blog for November 2015. This is a summary of all of the latest employment law developments during the last month. We have 4 key things to bring you this month, starting with the latest review of employment tribunal fees that was announced in the last month. What we are seeing is a development whereby tribunal fees are being challenged. This arose following the election in May, and the latest proposals look at reclassifying tribunal fees into 3 tiers rather than the current 2 tiers, a reduction in fees for paper hearings, that's where people don't actually attend, additional fees for preliminary hearings. We're in divided opinion about this because actually we like preliminary hearings, and removing preliminary hearings removes the ability for employers to get preliminary issues dealt with early, and also the quite frightening prospect of fees for respondents in the context of filing a response form and for a hearing fee. Moving on, we've seen the latest development in the long-running case of Nolan versus the USA. This was the case relating to whether collective consultation applied to the closure of a US airbase. The case originally going all the way up to the European Court of Justice and now coming back down to the Supreme Court, where the Supreme Court has confirmed that collective consultation obligations did apply to the closure of that US airbase, and therefore the employees there are now on potentially for protective awards of up to 90 days pay, although the original tribunal awarding only 30 days in those circumstances. Second case for you this month is to deal with the issues of public interest in relation to whistleblowing cases. As many of you will have seen, the recent decision of Chesterton and Global Limited versus Muhammad, this case related to a number of employees who were complaining about their terms and conditions of employment. We've had a recent development in the case of Underwood and Wincanton in the last month, whereby it was held that public interest related to only 4 employees. The Chesterton decision is still a subject of appeal, so we wait for further developments as to what the meaning of public interest actually is in relation to whistleblowing, and this is likely to be an on-running saga which we'll be reporting to you over the next few months. Finally, this month we're talking about exclusivity clauses in 0 hours contracts. The 0 hours contract, as many of you will be aware, has been an issue again of much political debate, and now the government have come forward with the latest set of regulations to redress the 0 hours contracts and how in particular the exclusivity provisions should not be enforced. In particular, we're looking at automatic unfair dismissal rights for employees and detriment rights as well. Potentially the automatic unfair dismissal rights not requiring qualifying service, detriment rights working in the same way as many other forms of detriment claims operate. So this is a development which we wait to see what happens. The regulations are currently in consultation, but a clear warning to employers to make sure that you don't have exclusivity provisions in 0 hours contracts. That's all we have time for this month. Obviously this update is no substitute for proper legal advice. If we can be of any assistance to you at Herrington Carmichael, please do not hesitate to contact us. Have a very nice month. Thank you.